Okay, let's go on the record on cause number DC 214026, NRA Pixis Investment Group, LLC. Counsel, make your appearance.
Good morning, Your Honor. My name is Chandler Winslow, and I'm from the law firm of Russo, Naftis, and Massengill. I'm here representing petitioner.
All right, let's go forward. You have with you Miss Mindy Jones, is that correct?
That is correct. And she is from Pixis.
Okay, let's proceed.
Would you like to hear? Okay. Your Honor, we're here today on a petition for a pre-suit deposition pursuant to Rule 202. I represent Pixis, which is a concierge care group, and they entered into a service order with a company called Access Technology Solutions. They have been doing business for a little bit, and the problem that we have here is that the service order, which I'll get into, references some other contracts which were not provided to my client. So really just the straightforward thing is we are trying to get a copy of our contract to see what remedies we might have. I previously emailed to the court coordinator copies of petitioner's exhibits, and I'd like to offer petitioner's exhibit D, which is a copy of the notice letter that we sent back on April 6th via certified mail and first class mail to the registered agent of Access Technology Solutions. It includes a notice of this hearing, as well as the petition that was filed and the green card showing acceptance of the petition.
All right, so it looks like you sent us exhibits A, B, C, D, E, F, but you're just only asking for the admission of exhibit D, is that correct?
At this, well, I would ask that all exhibits A through F be admitted.
Exhibits A through F are admitted? Okay.
And again, exhibit D shows that we did provide notice of this hearing. In addition to that, petitioner's exhibit E will show that a trial subpoena was served back on April 8th, 2021, and that was served on the registered agent as a custodian of records for Access Technology Solutions. To date, we have heard nothing from the company. And really what we're trying to do here, Your Honor, is, again, our clients entered into this agreement. It's the service order, which is marked as petitioner's exhibit A. As you can see from this, it's a one-page document. If you look at the bottom, there in all caps, it says this is a binding agreement subject to the terms and condition of the access service level agreement and the business associates agreement that is available on the public website gives this link or upon request. Our client at the time of signing this, which was on January 30th, 2019, was not provided with any other agreements. Subsequently, they've had issues with the services provided by Access and have requested termination. The issue that we have here is that the agreements, when you click on this link, that they refer to in the service document, the current active access service level agreement, which is petitioner's exhibit B, is dated October 25th, 2019. So they're referring to an agreement or a contract that postdates the date of their service order. My client has gone through hoops to try to request that they be provided with the agreement that was in effect at the time of their service order. And that
are they currently providing services to your client? I guess I'm not exactly clear what's going on.
Well, so our client tried to terminate the services because they were not provided my client was not provided what was promised. They no longer need the services, but because we do not have an underlying contract besides this service level agreement, I can't even advise them as to what happens if, if they stop payment. Right. I don't know if there's an acceleration clause. I don't know what that leaves them open to. And so my client is continued to pay them monthly because we don't even know who to provide notice to.
Is there somebody that they work with at the company?
I don't know. I mean, both myself and my client have contacted the company multiple times. Again, I've tried to call their legal department, or I've tried to call and request their legal department. The way that this company works, from what I can tell from my experience with them, is that they outsource their reception. So it comes in and a ticket is generated. I went in and I tried to, even myself as an attorney, I was an attorney, I went and emailed their support and said, I'm here, I'm representing Pyxis. Please have your legal department contact me. Nothing. What happened was, and I believe that this is also part of Exhibit C, you'll see where I emailed their support and got a generated document back that said, we don't use this anymore. You should go and look at the online, support system, or you can have your designated super user for your agency start a ticket. So also part of this Exhibit C, following those directions, I had my client go and start a ticket that specifically says, please reach out to my attorney. Here's her information. No response. That was back, let's see. That was back on March 1st. I've started tickets for just even speaking with the registered agent. None of it's returned. I followed up on tickets. They say it's a process. It has to go through legal. I explained that we have a hearing and I'd like to, talk to them because it's very simple. We need a copy of the agreement that was in effect at the time of the service order.
So I'm looking at this. This isn't what is this exactly that you provided?
Okay. So here is where we ask, so that screenshot there, that is a copy of the service order, which is also our, the one page, it's our Exhibit A. So when my client asked, may I please have a copy of the underlying agreements, they sent Access sent a screenshot of the service order, again, which we have, but the service order references you to this website. So
it looks like she's been dealing with somebody named Cindy Ryan. Is that right? Or Raina?
Cindy Raina, yes. So after as you'll see here, so after our client tried to explain, okay, thank you, you sent us a screenshot. We need what you're referring to as the legal terms, these other agreements. My client never received a response to that. That's when I went in and I tried to say, hey, please just have someone contact me. Because I thought if I could have a phone call with their legal counsel, I could get this sorted out without having to go through all of this.
Did you try to email this person, Cindy Raina?
Well, my client did, as you'll see, and where she said, no, we're looking for this agreement, and she never responded. Cindy Raina is I believe, their representative. Is that correct, Mindy? Yeah, that's their representative. That's not their legal department.
He's in the customer service department.
Okay, thanks.
Okay. Because I mean, at least that's a live person, I guess, was my thinking. Because it sounds like
yeah. I mean, so when she never responded to the email that said thank you, but that's our service order. We need the agreements that you've highlighted in here. That's when I went to the terms of their current service agreement to see how you're supposed to provide notice. And under that, it refers you to email support, which I did. And then I got, if you look at the next thing, then you get the email from support saying, this isn't how we communicate anymore, start a ticket. And so then I had my client start a ticket.
Okay. I guess my main question just by looking at these emails is at least Cindy Reyna was responding at some point. And
She responded, yeah, excuse me, she responded until, so they just, what they keep doing, and this is not the first time that this has been requested, this happened last summer in June and July as well. What they keep doing is they keep just resending again and again the service order, which is a one-page document, and a link to the agreements that postdate the service order. So if you look, if you look at Exhibit F, that's what you'll see. This is the second time we've gone through, or my client has gone through this, and it's just circular, Your Honor. It's just over and over again.
Say Exhibit F is what you want me to look at. Okay, and then there's who.
So if you go to the bottom of if you go to the very last page, you'll see where again, my client requested a copy of the contract, asked if it was this one page. He says he'll get back to her. Then he does. It's not 3 to 4 pages. We've never received anything more than one page in the link. And so if you go to the bottom, you'll see again where it should, wait. There should be one more page. Yes. So attached to this was the one-page service order along with the same link that takes you to the service agreements that postdate the service order.
Okay. I mean, to be honest, my main concern is just that it seems like there were live people that were responding, and then you went through some kind of automated system when you were trying to contact them. And obviously it should work, but we all know with those types of systems, sometimes they don't, and you did have a live person. I mean, I'm okay with signing this. I just want to share my concern is that I think that you could. Did you email these folks, Cindy Reyna and that Jinmon person, that to tell them about this hearing?
No, we didn't email them about this hearing. We just went through the registered agent pursuant to the rules. But we did email. We emailed.
Did you actually email? How did you serve the registered agent?
By certified mail.
Okay. And it was the registered agent a person, or was it like a CT Corp? Or
it was a person who signed it's the registered agent is a person who is at the headquarters of the company.
And where are the headquarters?
They're in Dallas. Looks like right off of Dallas Parkway. And I do believe that we also emailed the client representative asking them to have the legal department contact me.
Okay.
So.
All right, well, go ahead and yeah, I'll go ahead and sign this. I will say that, I'm a little concerned with how this was, going through the automated system when you have live people, but we'll kind of deal with that.
I did speak to live, right. I mean, I did speak to live people. every time that I called. It was just that they would not transfer me to the person I was requesting to be transferred to.
Would they send you just a voicemail?
They would create a ticket and I would call back and I would reference the ticket number and say, what is this about? Because I wanted to make sure that it was accurate. And they said that you need a return phone call from legal and your name is Chandler Winslow and this is your number. So there was, we have done everything that we can short of physically driving up to their headquarters to try to resolve this.
Okay. All right. Well, I'll grant the relief, and we'll go from there. So, Rhonda, I sent you a copy of the order to sign. So go ahead and print that out, and we'll try to get that signed on Monday, and then it should be up on the system by Monday afternoon, so Monday evening. All right.
Thank you so much, Your Honor. I appreciate your time.
All right. Thank you. Bye-bye.
Bye.
All right. It doesn't appear like everyone's here yet for this hearing. Am I right about that?
Who do you believe is missing, Judge?
Eugene DeBose?
Oh yeah, I don't see him here.
Yeah. I mean, how are you guys today?
Morning, Your Honor.
Good morning.
Doing well, Your Honor. Good morning.
Morning, Bree. Good morning, Dan.
Good morning, sir.
Good morning, Tony.
Good morning, Nico.
Do you want me to, or Dan, do you want me to email Gene DeBose or Bree, either one of y'all?
In the
It-
past,
We can email.
yeah, I mean, in the past, he's indicated he doesn't represent Brian Martin, only Holly Martin. And so I don't know what to tell you. I don't want to say you darned if I do and darned if I don't.
Yeah.
Right.
I have a hard enough time giving advice to my own clients versus
Right.
Fair enough.
I made everybody chuckle. That's the end of it. I'm done. I'm going back on mute, Judge. Bye.
Now you can enjoy the weekend.
Adios, muchachos. I'm back on mute.
All right, I'll go on mute too.
Okay. I'm assuming he was served with this motion, Mr. Martin.
That
Is
is
that
correct, Your Honor. Yes.
Okay. Tony, you ready?
Yes, Judge.
Let's go on the record on cause number DC 209893, Moss v. Princip. Counsel, make your appearances.
Bree West on behalf of plaintiffs.
Oh,
Mr. Hurst.
I'm sorry, Your Honor. Michael Hurst here on behalf of non-parties, Google and YouTube.
Dan Wyatt on behalf of the plaintiffs.
Let's proceed.
Thank you, Your Honor. Plaintiffs filed a motion titled Motion to Strike Judgment Debtor's Original Answer and for Default Judgment as to Liability. We, through our motion, obviously presented the court with all of the facts that support the request that we're making, which we believe amounts to death penalty sanctions and the striking of this judgment debtor's original answer and default judgment as to liability. We also filed, Your Honor, the order, which I think summarizes what we put in our motion down to 7 points that we believe support our request. Specifically, Your Honor, and for the record, we'd like to point out that judgment debtor has failed to do the following. Failed to comply with the temporary restraining order that was signed by this court on September 18th, 2020. failed to comply with the order to turn over that was signed by this court on September 21st, 2020, failed to comply with the orders compelling post-judgment discovery that was signed by, or that was dated October 9th, 2020, failed to comply with the temporary injunction that was dated for October 15th, 2020, failed to comply with the order compelling the turnover of non-exempt property that was dated November 23rd, 2020, failed to comply with the March 1st, 2020 order from the bench in open court for the judgment debtor to comply with orders to show cause, Your Honor, to personally appear and not be held in contempt of court on March 22nd, and Your Honor, failed to appear in court on March 22nd as ordered by Your Honor.
Let me just kind of ask a question here. I'm not opposed to doing this. I'm just trying to think through this. So my eventual goal in this case, or hope in this case, I shouldn't say goal, hope in this case, is that eventually there'll be a trial between that kind of, my hope is that eventually he'll comply with everything and turn over all of the information that he should have turned over a long time ago. But concerning the YouTube channels in particular, there's an argument that Mr. Martin owns them. There's an argument that Mrs. Martin owns them. And there's, that to me is the kind of at least at this point, the main sticking point in the case ultimately. And so if we go to trial on this case, then on that issue, and you have a default judgment as to Mr. Martin, how is that going to, I guess, matter in the eventual trial of this? I mean, or how do you anticipate that this case is going to end up?
Well, quite frankly, Your Honor, this is sort of a means to that end, if you will. In other words, Mr. Martin has failed to comply with any order coming out of this court. And what our hope is that by engaging in what we're doing today, we'll get Mr. Martin's attention enough to be able, that would cause him to then comply with the things that we need, because we need to be able to get to a final resolution. We agree with you, Your Honor. And I think that we're glad that there are some of the other attorneys that are involved, because we are moving the ball forward with them. But Mr. Martin is not complying in any way. And that is the main stall in us moving this and resolving this case finally. And so we're hoping that this order that the court will hopefully grant will get his attention enough that his original answer will be struck, that the court will find that he hasn't complied with any of the orders coming out of the court, and that will cause him then to respond. And if and when he does, then we can move forward to the final resolution of this matter.
But will it, and I get all that. I have no problem with that. I guess my question is vis-a-vis Mrs. Martin in the eventual trial of that dispute, this order really, maybe this is for another purpose. This order really won't impact that trial because it's not going to affect her claim of ownership over those channels, right?
Well, I mean, her claims with Mr. Dubose and things like that are being, simultaneously litigated, and there's a hearing on that at a later time. But at the same time, I think it's relevant here that that Mr. Martin has earlier claimed the ownership of these channels, and now he's saying that he doesn't state the ownership of these channels. And so by the court taking this action, I think that would move the ball forward in resolving that issue as well. But
it wouldn't preclude Mrs. Martin from making the argument that she owns the channels.
Right. I mean, she certainly can make that argument, Your Honor. I mean, we obviously
disagree.
But right. And I'm not going to litigate that here, but there's lots of things that don't support that. So, but yes, she's obviously entitled to be able to make whatever claim she wants to. And
Mr. Hurst, obviously you're the one who's kind of holding the golden goose right now. Do you, I don't want there to be any kind of misunderstanding about what is happening here. you understand that you're to continue to hold the funds or continue, I don't remember if you're holding the funds or putting them in the registry of the court, but you're not to distribute those to the plaintiff until we get a final resolution of this. Does that make sense?
We do understand that, Your Honor, and I've tried to give as detailed of an explanation as I could upon visiting for the last few weeks with our clients based upon your last hearing. And we sent a letter to you. I don't know if Your Honor's had a chance to review that. We sent a letter.
I don't think I've seen it.
Okay, we sent a detailed letter about exactly what was going on, what we're doing, all the mechanics behind it, because I wanted to be very transparent about what it takes and the challenges that we've had, but also that we're doing our best to comply with Your Honor's orders.
And I think, Michael, you requested a status hearing that we were hoping to get scheduled today. Is that right?
I'd love to schedule a status hearing, not to be set for today, but we could schedule it for.
You know what day this letter was sent? Because I have not seen the letter, so.
Oh, wow. Okay, hold on one sec, Your Honor, if I can look real quick.
Apologize.
No,
And
I
I think-
apologize if it didn't get to you.
Is that 331 maybe, or?
No,
I
it's.
think we got it on 3/28. I mean, excuse me, 4/28, I believe. Your Honor.
It was just the other day. Judge.
Okay.
And,
Wednesday, I think.
And let me share screen so that we can kind of figure out what you're talking about.
it was dated April 27th, Your Honor.
Okay. Is that letter to court regarding motion for reconsideration? You see on the screen what I'm talking about?
Right. Yeah, I see that. I don't know that it was really a letter regarding the reconsideration, but maybe that's how it got titled somehow in the system.
Let me see.
We're not sure if that's it.
I
It was
see a
April
bunch of motion.
27th, so the date would correspond with that being the letter.
Notice of filing e-serve discovery responses. That's not it, is it?
Are you able to open those from your scroll there?
Which one do you want me to open?
The 427 one, the one that said reconsideration. I wonder if that's it.
Let me see. Yeah, it's for some reason I can't. I don't know why. It happens occasionally. Would you mind just emailing the letter to Rhonda and Rhonda, just put on the letter urgent, on the title urgent, Mr. Hurst.
Okay.
And Rhonda, go ahead and print that out and put it in my stack. For some reason, it's not here, so that I can see at least.
Okay. I'm emailing it to Beverly to send to Rhonda immediately.
Okay, it'll come from Beverly.
Yes.
Okay. Okay, and let me make sure we have the correct order you wanted me to sign for today.
Oh.
And Your Honor, the last thing that I just wanted to make sure, two additional things, just if the court can take judicial notice of all of the pleadings in the court's file that support this. I think you've already done that once, but for the record, if the court would be willing to do that.
Sure, I'll
that's
take
really-
judicial notice.
Thank you, Your Honor. And then in the order, we do request attorney's fees. And I didn't know if the court wanted to hear from me on that.
Go ahead.
There's a reasonable amount of attorney's fees. We're requesting $6,000 in attorney's fees in preparation of this motion and obviously argument today. We did obviously case law research related to that. Both Dan Wide and myself worked on putting together this motion. And it is approximately seven substantive pages, including the case law references, and the preparation of the order, as well as oral, just any argument today.
Okay. Any objection by Mr. Hurst?
No, we don't feel like we have any dog in this fight, Your Honor.
Okay, so no objection.
No objection, Your Honor. Sorry, I apologize.
That's okay. Just wanna make
None
sure.
from me.
Okay, all right. Well, you're on the same side, so I assume you would. All right, go ahead and, so I want to make sure that we're looking at the correct order here. So let me share screen this.
Yes, so the order would have been filed yesterday towards the end of the day, so that would have been, yes, 429. I think
Rhonda,
so.
if you could go ahead and print this order out. It was from 429.
That's the correct order, Judge, that you were just looking at.
And so it's the non-signed proposed order judgment on 429 regarding the motion to strike. Rhonda, do you see that on the screen? Okay. All right. And then remind me again, when are we having the ultimate trial on this case, I guess?
I believe it's set in October.
October, okay. Sounds good.
May I
Anything- Yes.
mention, it's set for October 5th, and actually, the court, Mr. Capua, had forwarded a letter to Mr. Dubose, providing notice of the October 5th setting, since they got in after the court sent its original. And, long story short, it's set for a non-jury trial, and, I don't know if somebody's going to come in and file a demand. We don't see a need for a jury,
So I'm wondering about this, and maybe we could talk about it when Mr. DuBose is here. If this is going to be a non-jury, and I think it kind of makes sense it's a non-jury, but we're starting up, as most of you guys know, we're starting up jury trials on a very limited basis in June and July.
Right.
I don't know what's going to happen. Yeah, I know Michael's clapping. I have too. In August forward, I'm not sure kind of what we're going to do. It depends on kind of what how these trials go, if we have any issues with COVID, all that kind of stuff. And so it might make sense when we originally sent this to do this in October, because we really didn't know back then when it was originally set, we didn't know what our trial schedule was going to be. Now we have a somewhat better idea. Anyway, my point is, you might want to talk to Mr. DuBose about moving this trial setting up to an earlier date if we're going to do it non-jury, because once I start doing jury trials on a regular basis, it's going to be hard to reach non-jury cases. So something to talk to Mr. DuBose about. I don't want to do it today, but we have a hearing on Monday with him, I think.
I believe so. Also, Your Honor, since we do have Michael here, in response to that letter, are we able to get a date for a status conference from the court on that?
You don't want to just do it on Monday?
Oh, that's fine. I mean, I didn't know if that worked for you. That's fine with us.
I'm available to do it on Monday. Is there a concern about not giving enough notice? But by the way, we just sent that email to Rhonda.
Okay, good.
I think everybody has notice for Monday. Is that right? I think so.
It's just a status conference, right? You're not asking me to really.
Sure.
Yeah, go ahead and Rhonda set a status conference for this case on Monday, and then Mr. Hurst, if you can send an email out to everybody, just letting them know that we're going to have a status conference on Monday.
Okay.
About this topic.
I'm doing this right now.
And I want to note for the record that Mr. Moss just joined the Zoom.
Thank you, Your Honor.
Okay, anything else, guys?
That's it, Your Honor. Have a great weekend.
That's
All
it.
right,
Thank
you too.
so
You
much.
guys be safe, okay?
Thank you. Good seeing everybody.
Thank you. Bye-bye.
Stay dry.